18 July 2026, and this is Live 2 premiere session. The world's first AI treaty has a loophole, and it's called Article 3. Imagine the world finally agreed. 46 nations, the United States, the United Kingdom, the European Union, Japan, Canada, Israel, all signed the same document, a legally binding international treaty, specifically designed to govern artificial intelligence, the first of its kind in human history. Now, tonight's puzzle for each one of you. Does that treaty actually bind any AI company, any private developer, any foundational model provider, any autonomous systems vendor right now? Yes? No? Or something far more complicated? Hold that answer. 10 minutes of this presentation and we resolve it here. Before I go further, call it comments right now. Does the world's first AI treaty bind a private AI company today? Yes or no? Live chat. I may read out your live chat messages tomorrow before I start Live 3. And I want to see here, I want to read your calls before the reveal. So yes, this one splits rooms of lawyers, so don't overthink it. Comment. Good evening and welcome to the AI Law Daily presentation, that is live premiere, and this is Live 3 today. I'm your host, Nupur Mitra, a techno-legal analyst and human rights lawyer, a registered lawyer, and this is your daily 10-minute live analysis at the intersection of artificial intelligence, international law, and the governance gaps that neither has yet mapped for the other. Yesterday in Live 1, we examined how domestic eminent domain law is being mobilized in service of AI infrastructure and how international frameworks address that scenario only partially by analogy. Tonight we go one layer deeper, because last night I left you with a gap. Tonight I want to show you the instrument that was specifically designed to fill it, and then with precision I want to show you exactly where that instrument leaves the gap open. On May 17, 2024, the Committee of Ministers of the Council of Europe adopted a document with a long name and a significant claim. The Framework Convention on Artificial Intelligence and Human Rights, Democracy, and the Rule of Law. On September 5, 2024, it was opened for signature. Among the first signatories, the European Union, the United States, the United Kingdom, Israel, Norway, Georgia, Iceland, San Marino. By May of 2026, 46 signatories had signed. Academic commentary was swift. Writing in the University of Illinois Law Review in December 2024, legal scholar Cheng-Chi Chang described it as, I quote directly, a watershed moment in the global effort to establish common standards for AI governance. The essay was published under the title, The First Global AI Treaty. The description is technically accurate. It is the first legally binding international instrument specifically focused on artificial intelligence. So, 46 nations, a peer-reviewed designation as a watershed moment, an instrument grounded in human rights, democracy, the rule of law. The question is not whether this treaty exists. It does. The question, as your puzzle tonight asks, is what it actually binds. Let us build the legal architecture and let us be precise. Article 3 of the Framework Convention establishes its scope. This is the provision that determines who is bound by what. Article 3.1a, it states clearly the convention applies to activities within the life cycle of AI systems undertaken by public authorities or private actors acting on their behalf. That is a firm obligation. Governments, state bodies, public institutions, and companies operating under government contracts. But Article 3.1b, and this is the governance gap I want you to understand tonight, addresses private actors who are not operating on behalf of a state, the developers, the foundation model providers, the autonomous systems companies. For that category, the convention does not impose a direct obligation. Instead, it requires each signatory state to specify in a declaration how it intends to address risks from private actors. And crucially, the convention offers states a choice. They may apply the convention's principles and obligations to private actors, or they may take, in the convention's own language, other appropriate measures. That phrase is not defined. The explanatory report does not define it. As legal analysts Carolina Babica and Christina Giacomin of the International Commission of Jurists wrote in November 2024 in their published analysis on Opinio Juris, and again I quote directly, this lack of clarity can be detrimental to the certainty and predictability of the law. They further note the risk is even more serious considering the important role of the private sector plays in the development and deployment of AI systems. This is not a fringe critique. It is the formal analysis of the International Commission of Jurists. And then there is Article 3.2. Article 3.2 establishes a blanket exemption for, again in the convention's own words, all activities within the life cycle of artificial intelligence systems related to the protection of national interests. All activities, all national interest designations determined by each signatory state. The same analysis observes that this national security exemption applies regardless of the type of entities involved, meaning even private companies could fall within it if a state declares the activity relates to national security. So let us map the architecture clearly. The world's first legally binding AI treaty applies directly to public sector AI. For private sector AI, which is most of the AI being built, deployed, and scaled globally, application is optional, subject to a state declaration using a standard whose content is legally undefined, and activities touching national security are exempted entirely. Chang's 2024 Illinois Law Review analysis names these limitations directly. Potential limitations such as challenges in enforcement, possible regulatory fragmentation, and implementation hurdles. These are not secondary concerns, they are structural. Before I resolve this, where do you stand? Should the private companies actually building AI be bound by international treaty? Or is binding governments enough? Comment 1 for binding the companies directly. Comment 2 for governments are enough. One word, and I want to see this room split. So, tonight's puzzle. The world's first binding international AI treaty was signed by 46 nations. Does it legally bind any AI company right now? The honest, precise answer has 3 parts. First, the convention requires 5 ratifications, at least 3 from Council of Europe member states, before it enters into force. Signing is not ratification. A signature expresses intent. Ratification creates a binding obligation under international law. Those are different legal acts. Second, even once it enters into force, its application to private AI companies, the entities actually building and deploying the systems at scale, is not automatic. It is subject to each state's declaration and other appropriate measures. That clause remains an undefined standard. Third, national security activities are categorically exempt. In a world where AI infrastructure is increasingly framed as a matter of national security by multiple signatory states, that exemption is not narrow. The Framework Convention is a genuine advance. I agree. The first binding principle, yes. The first global treaty architecture for AI governance, and that matters. But binding in form is not identical to binding in effect. And a treaty that leaves private sector coverage optional and national security activities entirely exempt has not closed the gap we examined last night in our Live 1. It has named it more precisely, yes, but that is progress, definitely. It is not resolution. Tonight's takeaway is this. International law moves through a process. Soft law instruments first, then treaty frameworks, then ratification, then state practice, then, over time, customary international law. The Framework Convention is a real step in that process. Yes, but its effectiveness will ultimately depend on addressing enforcement, fragmentation, and the private sector loophole that Article 3 built in by design. One more thing, and it matters. Article 3, the Babica and Giacomin analysis, Chang's essay, the full ratification mechanics, they are all there at thoughtleadinnovate.com in my newsletter. Subscribe there. 10 minutes here is the argument every week for 4 days. Thursday, Friday, Saturday, Sunday, 8 PM CST as of now. The newsletter at thoughtleadinnovate.com is the evidence, the primary texts, the citations, the footnotes you can take into a courtroom or a classroom, free of charge, in your inbox. Subscribe tonight. Tomorrow, Live 3, we examine how the European Union's AI Act intersects with this convention. Same binding ambition, very different regulatory architecture, and a specific question. Can regional hard law fill the gap that a global framework left open? 8 o'clock Central. Be here again tomorrow. If tonight added precision to how you think, please follow me on this channel, the AI Law, on my website, thoughtleadinnovate.com newsletter, and also on my LinkedIn, Substack, and Instagram, because I don't want to depend on any platform to converse with you. This is the AI Law, Global Security, AI Risks and Liability, and this is its live premiere, Live 2, the AI Law Daily, governed by evidence, guided by law. Have a good night.